Now back to one of our top stories of the day, where the High Court in Gauteng in Johannesburg has ruled that an auction of the company's assets was unlawful, and the company under question is Bosasa. Acting Judge DP de Villiers summarised the circumstances of the complex case in his ruling, saying that things went south for Bosasa after the Zondo Commission heard evidence on the company's dealings. Now, for more details on this ruling, I'm joined by Jared Watson, who is the Director of African Global Holdings, formerly known as Bosasa. Good to have you with us this afternoon, Jared. Your reaction to this particular court ruling, you'll remember in December of last year, just before, days literally before the liquidation was scheduled to take place, you had made an application for business rescue. We've managed to go through most of, or part of, the ruling that the judge made, and some of the things that he says is this. He says, they, meaning the liquidators, they crossed the line in the litigation and they acted unlawfully in two major respects. One, disregarding the Bula order, and two, the business rescue application. Now, I'm sure you perhaps were not surprised by this, because when the liquidation was taking place, this is literally what you were contesting, the fact that business rescue hasn't taken effect.
Yeah, basically what we did was there was a discussion that transpired between the legal representatives from both sides, and we said that African Global hadn't given authority to proceed with an auction. It was very bad timing. It was done with 7 days' notice, and some of these assets had value of in a region of 300 million rand. And to give the public only 7 days' notice that these assets were going to be sold was just ludicrous. So we had been in discussions, or the legal representatives have been in discussions to say, you require the consent of the company if you wish to sell any assets. They knew this, they were aware of this, and the court order reflects that they acted deliberately and in defiance of a court order, and then a second court order of effect when the business rescue application was made, and they just proceeded as they wished, assuming that we would have no mechanisms to bring against them. What they effectively did was they wanted to use the company's own money to fight against it, in hoping that they wouldn't be able to be successful in overturning this auction. But it transpired, orders brought about illegally, and the court has found that. And we warned the public at the time to say, guys, this auction is proceeding illegally. They have no legal rights to proceed. They're only provisionally appointed liquidators. They have no authority of the company itself. And they just did it anyway, completely illegally. And the court has now found that.
So where to from here, Jared? Over 100 million rands worth of properties, including the Lindela Repatriation Center, and two other properties. There's the copper mine. There's business furniture. There are people who have acquired or bought these properties. What next for them?
That is the great question, is how does one unscramble the eggs? I just want to correct you on a statement that you made, in that it's 100 rands worth of assets. It was actually in the region of a book value alone, not even market value, book value of assets of in excess of 1.2 billion rand of assets that were sold for a value of 100 million rand, just showing how poorly conceived this whole idea was of going to auction. It was done at a spur of moment against a court order, and it was done so illegally. So now we're tasked with we're given the great task of having to unravel what should be still allowed, or what should be considered to be a bona fide sale, and what should be reversed. This was the eggs were effectively scrambled by the liquidators, and they've created this unsightly mess. That the High Court has now said, well, we have to undo the damage that was done. The next steps that you asked me, well, now we need to think about what legal action needs to be instituted against the liquidators. They potentially eroded in excess of 1 billion rands worth of value at a whim. So now the next step is to consider how do we deal with these liquidators who've acted illegally and done so willfully. So now we need to bring an application to potentially remove the liquidators, and to bring a claim of damages against them, because they've acted substantially to the detriment of the group. That they're tasked with looking after the best interests of the group and its creditors, and they've done the exact opposite of that.
Is it a possibility Or is it even an avenue that you are wanting to explore to try and retrieve these assets? As you were saying, yes, they were indeed sold for 100 million rand, but they were 1.3 billion rands worth of assets. Are you going to try and get those back?
So that is something that we'll have to consider. You'll have to look at each sale individually. Substantially, the immovable properties of the company hadn't transferred. You mentioned the Landela Repatriation Center. That has a book value in the region of 200 to 300 million rand. And as you say, the full proceeds from the auction was 100 million rand. So it just didn't make sense. So now the immovable properties have yet to transfer yet, and this has now put a stay on that. But now each movable asset that was sold, someone or whoever's tasked with that will have to look at each sale and say, do we consider this to be a bona fide sale? And if so, then it will most likely remain transferred, and if not, it will have to be reversed. And where value was eroded by the liquidators, an application for damages on each and every sale that was made in defiance of these two court orders, a claim will have to be made against them, and legal process followed in recovering the funds from the liquidators.
You mentioned, Jared, that one of the steps that you are potentially going to take is advocate for the removal of those liquidators. With the status quo and in respect to the judgment that's just been meted out, how could they possibly react? Can they appeal this?
They can appeal the decision, of course. I mean, any decision of the High Court is or they can file for leave to appeal. Then the judge needs to decide if there's merits to an appeal, and then he can choose to provide that or not, in which case they can appeal to the Supreme Court. That's for the judge who made the ruling. That's his decision now to make, to say, do they even have grounds to appeal here? I mean, given that they've acted, it's verifiable, they've acted illegally, they've acted in defiance of two court orders. They did it regardless of numerous warnings before the auction to say, don't do this, you don't have the required authority to proceed, and they did it anyway. So they will have to now potentially consider if they wish to appeal. Then the judge who made the ruling will have to decide if he believes there's grounds to appeal. But that's a decision that's up to them now, I guess.
And what is the current status of African Global Holdings?
It is still in liquidation. This application and this decision that was made doesn't affect that. The company is in liquidation. It is just a ruling on the, how would I call it, on the conduct of the liquidators in proceeding with the auction, which is effectively to try and, from the liquidator's side, to try and rid the company of all its assets in a single event without any substantial warning. So it doesn't change that the company remains in liquidation for the time being.
All right, Jared, we'll leave it at that for today. Thank you for that update. That's Jared Watson there, who is Director of African Global Holdings, formerly known as Bosasa. Now, part of that 100-page ruling that the judge meted out, I'd like to read one point from that. The judge says, in light of those findings, their unduly aggressive litigation becomes even more unacceptable. It was argued before me on their behalf that upon winding up, the law takes control of the company in litigation, or rather in liquidation. My distinct impression was that the provincial liquidators equated that concept with themselves. Rather scathing there, with the judge saying that the liquidators basically took the law unto themselves and equated themselves with the law. We'll continue watching that very closely for you.